Assalamu alaikum, everyone. My name is Muhammad Ali Naqvi, and I'm the founding vice president of the American Muslim Bar Association. I'd like to welcome you all to today's webinar, Charitable Giving and U.S. Sanctions, to explore the intersection between sanctions laws, agency regulations, and religious obligations. Just over 2 months ago, 2 members of our Muslim community were arrested in Houston on charges stemming from charitable donations they allegedly collected from the community, some in the form of khums, and distributed abroad for the humanitarian crisis in Yemen. I say allegedly because the facts as we know them have only been shared so far by the US government. We will not know the full undisputed facts until the case progresses further and their attorneys formally respond to the government's allegations. Due to the attorney-client privilege, none of us can know their side of the story until then. It's important for all of us to remember that and not conjecture about the case, but to continue to pray for our brothers in distress. Also, if you are approached by law enforcement in regards to this case or for any other reason, remember to identify yourself, take their card, and tell them your attorney will be in touch with them. Please contact AMBA and we will put you in touch with an attorney. As far as we are aware, this is the first legal case involving khums to be filed in federal court. Not surprisingly, this has created some anxiety in our community around the Islamic obligation to pay khums every year. So today's webinar will seek to clarify some of the legal issues that arise from this case. We would also like to stress that the full ramifications of the case will not be completely understood until a legal decision is reached, which could take a year or more. What we would like to do today is to give you some guidelines to proceed based on what we know thus far. Today's program will begin with 3 presentations, which will be about 10 to 12 minutes each. The first will be by Oliver Krischik on US sanctions laws. The second presentation will be by the legal team at CUNY Clear, Naz Ahmed, Princess Masilungan, and Mudassir Topa on federal agency regulations. And the third will be presented by Sayyid Ali Tawfiq and Sayyid Sulaiman Hassan representing AMBA. We will then present some common hypothetical scenarios for individuals and organizations that our speakers will take turns responding to, which we hope will answer a lot of questions before you even need to ask. After that, we will have a Q&A using the webinar chat feature. You are welcome to pose questions as they come to you during the webinar, and also upvote if someone else's question applies to you as well. We will try to get to as many questions as possible. We will also provide contact information at the end so you can follow up on any individual specific concerns. With that, I'd like to introduce our first speaker. Oliver Krischik is a trade law attorney who focuses on representing businesses, individuals, and nonprofit organizations with issues surrounding economic sanctions, export controls, and financial regulations. He counsels his clients on licensing and enforcement matters, and his practice also encompasses general trade compliance for corporations and nonprofit organizations. Oliver also assists individuals in navigating U.S. economic sanctions applicable to personal transactions such as inheritances, immigration, and family gifts. This may include applying for specific licenses, filing voluntary self-disclosures, or otherwise advising on the applicability of exemptions or general licenses. In addition, he incorporates new for-profit and non-profit entities, drafts bylaws and related corporate governance documents, and applies for and obtains federal tax-exempt status for his nonprofit clients. With that, I'd like to welcome Oliver Krischik. Please go ahead.
Thank you. Okay, good evening or good afternoon to everyone. I'm going to speak a little bit about the U.S. sanctions laws surrounding Iran and charitable giving. As you've heard, I work primarily on U.S. economic sanctions as a practice area as an attorney here in Washington, D.C. First, of course, I need to give a disclaimer. You know, the information provided during this presentation is not legal advice. Sanctions in particular are a very fact-specific area of law, and you should contact an attorney if you have questions and want to obtain guidance on how laws and regulations may apply to your specific set of facts. We're going to cover some of the general rules on the scope of sanctions and their prohibitions. First, let's talk a little bit about who manages U.S. economic sanctions here in the U.S. government. That would be the U.S. Department of the Treasury's Office of Foreign Assets Control. So U.S. economic sanctions can come from a number of different authorities. They can come from congressional laws. They can come from presidential executive orders, but it's going to be the Office of Foreign Assets Control, or as we call it, OFAC, which is going to issue, administer, and enforce the U.S. economic sanctions regulations with respect to these restrictions. Depending on the sanctions program, OFAC rules may prohibit U.S. persons from engaging in business with certain parties, including with property in which certain parties have an interest. It may prohibit U.S. persons from engaging in business that involves certain embargoed territories. And at times, OFAC sanctions may prohibit transactions where there's no U.S. nexus at all. If a sanctions target is involved and the U.S. has determined that, as a policy, it's going to impose restrictive measures on foreign companies and foreign individuals doing business with those organizations. When we speak about sanctions targets, I think they come really in three varieties. The first is embargoed territories. This includes, of course, Iran, but also Cuba, the Crimean Peninsula of Ukraine, North Korea, and Syria. At the same time, there are some list-based sanctions which focus on certain individuals, organizations, and entities that are placed on what's called the Specially Designated Nationals list. Parties on the SDN list may be on there for a variety of sanctions-related reasons. It may include terrorist organizations, foreign governments, transnational criminal organizations, drug traffickers, money launderers, and so on. In addition to the parties that are on the list, there are also another set of sanctions targets, which are called blocked persons. And blocked persons is a title that applies to agents that are acting on behalf of SDNs or entities that are owned or controlled by SDNs. For this reason, it's important to know who you're doing business with and who the beneficial owners are of the companies that you're doing business with. When speaking about sanctions, it's under what's called a strict liability regime, which means that all technical violations are enforceable as civil violations. As a result, OFAC does not need to prove intent or knowledge to seek a civil penalty. They only need to show that a prohibited transaction occurred and that an organization was involved. As a result, they exercise their discretion by weighing a number of mitigating and aggravating factors when it comes to the enforcement process. In a lot of cases, they do not pursue civil penalties. Somewhere upwards of 90%, I believe, are resolved without any finding of violation or civil penalties, and they do this by reviewing a number of factors. Civil penalties are fairly strict in the US sanctions world. It's approximately 300,000 or twice the value of a transaction, whichever is higher per violation. And if you have engaged in kind of a set of activity, there may be a number of transactions which occurred there. And OFAC, like many other US federal agencies, would have no problem stacking some of those transactions and violations to result in higher penalties. Criminal penalties are also possible when speaking about violations of US sanctions. In particular, willful violations of sanctions are considered criminal offenses, and OFAC will typically refer those to the US Department of Justice for investigation and possibly prosecution. In this presentation, we're going to focus on the Iran sanctions. The Iran sanctions it's a countrywide embargo under what's called the Iranian Transactions and Sanctions Regulations, the ITSR or ITSR. The ITSR prohibits virtually all transactions between the United States and Iran. It applies to US citizens and residents wherever you are located. And there are a small number of very limited exemptions to this broad embargo, which include personal communications, where nothing of value is exchanged, travel, and transactions that are ordinarily incident to traveling to Iran, informational materials, and even there, it's very narrowly limited and must apply to informational materials that are in existence before a transaction occurs, and the humanitarian donation of goods to relieve human suffering or to meet basic human needs. Again, that is fairly strictly limited and typically won't apply to commercial transactions. Unless your transaction is exempt, if it involves Iran, it is going to require a general or specific license from OFAC under the ITSR. A general license is an authorization that applies to anyone who meets all of the conditions. It is narrowly written, and no further approval from OFAC is needed if a general license applies. General licenses can be found in the ITSR itself and on OFAC's website. If no general license applies, then a specific license will be necessary. A specific license is a little bit different. It is authorization you receive directly from OFAC that authorizes a particular set of parties to engage in very specific transactions that you've disclosed to OFAC beforehand. Specific licenses come on a piece of paper. It'll say, for instance, John Smith is authorized to engage in XYZ for this period of time. They typically last between 1 or 2 years, and that is a process we will talk a little bit more about in a moment. Examples of activities that would fall within the scope of the ITSR would be, for instance, providing any services to companies or individuals in Iran, receiving any services from companies or individuals in Iran, facilitating any activity between other parties and parties that are located in Iran, or sending or receiving any goods or technology to or from Iran. As you can see, it's fairly broad, and they made an effort to prohibit as much as they can under the ITSR. I think some of the questions that we're going to think about today and discuss a little bit further is, does the ITSR have a blanket general license or exemption for transactions related to Khums? No. But there are other licenses or exemptions which may apply in certain situations depending on what conditions are met and the circumstances. Another question that we often hear is, are charitable donations related to Iran always prohibited? And again, the answer is no. Some organizations may have obtained licenses from OFAC. They may be acting under existing exemptions or general licenses. And so it's, again, a kind of a case-by-case review where you need to ensure that the appropriate authorizations have been obtained. In addition to the countrywide embargo, another topic which may come up tonight is the list-based sanctions and the SDN list. US individuals and organizations are prohibited in engaging in virtually all activity with anyone who's on the SDN list. You're also prohibited from engaging in transactions related to property in which an SDN has an interest. And an interest means an interest of any nature whatsoever, direct or indirect. I pulled that language directly from the regulations. As you can see, it's extremely broad and leaves a lot of room for interpretation. On June 24th, 2019, the US Department of State, the Department of Treasury added Khamenei and his office to the SDN list under Executive Order 13876. Accordingly, moving forward from that day, US individuals and organizations would be prohibited from engaging in any transactions related to property or funds in which he or his office have an interest. And in addition, they would be required by law to block and report to OFAC any funds or property in the US or in a US person's possession in which he or his office have an interest. This status is separate from the countrywide embargo on Iran. And a question which we may be discussing a bit later in the hypotheticals is, would collecting funds on behalf of an SDN be prohibited under US sanctions? And the answer would be yes, unless there's some type of exemption or license which applies. When you're navigating the OFAC sanctions on Iran in particular, but it applies to other sanction programs as well, you need to keep in mind that any activity related to an embargoed country such as Iran is going to pose serious sanctions risk. If you or an organization identify any transaction that has a connection to Iran, you should ask a number of questions. Is this activity exempt from the ITSR and related list-based sanctions? Does this activity clearly fall within the four corners of the general license? And has OFAC granted a specific license to authorize the activity? If the answer is no to all three of these, then it's very likely that a specific license from OFAC is going to be needed to authorize the transaction before you can proceed. When navigating OFAC sanctions on Iran, it's important to understand how the sanctions apply to you, to understand whether any exemption or license exists before you engage in that activity. This involves asking for clear information from other parties on what exactly the transactions are going to be. For instance, individuals can ask organizations to explain what license or exemption they believe applies to the activity that authorizes it. You can contact a sanctions counsel or a lawyer to help you navigate some of these issues, apply for licenses, or seek guidance from OFAC. You can also go online and pull up the regulations yourself. Some of it's in legalese, some of it is a little bit clearer, but it's important to take those first steps in due diligence to understand exactly how the law is applying to you. You can also contact OFAC directly, but keep in mind that when you contact OFAC, if you're speaking about ongoing activity, which may be a violation, that may put you in a position where OFAC is aware of your identity and the activity, and so that can expose you to some risks. If a situation occurs where you want to obtain a specific license, these applications are submitted to OFAC on the Treasury website, which is somewhat convenient, particularly in this COVID world. License applications need to include specific information about the parties and the proposed activities. You can't just obtain a license to authorize you to engage in some open-ended activity without identifying for OFAC who is involved and what exactly you intend to do. Please keep in mind that OFAC can take 1 year or longer to respond to license applications. It does take them some time to respond. This is another situation where legal counsel can assist you with preparing the license applications to make them strong and to make sure that you're taking the right approach by applying for a license in the first place. If you encounter a situation where you believe you may have some blocked property or you may need to block some property because there is a sanctioned interest involved, this is a complex process. In the case of funds, it will likely involve your bank needing to set up special restricted accounts. It may affect your relationship with your bank. I recommend that you contact a lawyer. It's a complex process with some strict regulations involved. In terms of reporting requirements, if there's blocked property, you may need to report to the Department of the Treasury on a quarterly or annual basis. Again, these rules are strict and violating them can be a violation in and of itself of sanctions, even if you did not otherwise do anything inappropriate. So I recommend you contact an attorney. And very importantly, anytime you reject a transaction because it would violate sanctions, there is a reporting requirement to get in touch with OFAC and file a report. This is another situation where I recommend that you reach out to an attorney to help you navigate that process. That's it for my presentation.
Thank you so much, Oliver. Before we turn it over to the Clear folks, 2 questions came in, and I thought since this information is fresh in people's minds, I was wondering if you could maybe quickly just answer. The first is, do all these rules also apply to non-US nationals living in the US?
That is an excellent question. While you are located in the US, yes, the US sanctions rules are going to apply to you. They apply to US citizens, US permanent residents, US territory, which includes anyone who's located in US territory, and to organizations that are incorporated in the United States. In the case of Iran, it also applies to the subsidiaries which are owned by US parents. So if you have a company in the United States and you have a subsidiary located overseas and you own 50% or more of that subsidiary, or you otherwise control it, that subsidiary will also fall under the Iran sanctions, and OFAC can come after your US company, the parent, to seek penalties if they believe your subsidiary was engaged in inappropriate activity.
And the second question was, thanks for that. The second question was, so even trying to ask if you need a license can put you at risk?
Yeah, unfortunately, it can. The general advice that I provide is if what you're involved in is ongoing activity, it's probably best to get in touch with an attorney. One benefit of having an attorney is they can reach out to the government directly on your behalf and contact the government on a no names basis, for instance, to obtain some guidance without disclosing your identity. In other cases, if you've been engaged in ongoing activity, which may be a violation, but you want to apply for a specific license, yes, you're unfortunately in a position where you may want to, for instance, file a voluntary self-disclosure with OFAC, disclosing to them possible violations in the past before you send in a specific license. Because if you send in a voluntary disclosure, you actually get a number of credits in your favor when it comes to any type of OFAC investigation. But that is an issue we see come up a lot. And that is a good time, I think, to contact counsel and get some feedback.
Right, great. Okay, so the questions are coming in, so I think the rest we'll leave till the end. Or can you see the questions, by the way, in the Q&A? If you feel that you can answer them on the chat, you can do that as well.
Okay. I see them. I think it might help to do them at the end, but I'll read through them and so I'm ready when we get to the end.
Okay. Okay. All right. Thank you so much again, Oliver, for that presentation. Very useful. Great information there. I'd like to now go ahead and introduce our attorneys from CLEAR. Naz Ahmed is a staff attorney with the CLEAR project. CLEAR aims to address the unmet legal needs of Muslim, Arab, South Asian, and other communities in the New York City area that are particularly affected by national security and counterterrorism policies and practices deployed by various law enforcement agencies. Through her work at CLEAR, Naz represents individuals who are approached for questioning by local and federal law enforcement, targeted for surveillance, or placed on federal watch lists, or who have had immigration benefits withheld from them on national security grounds, and Yemeni Americans who have had their passports wrongfully revoked by the Department of State. I'd also like to introduce Princess Masilungan, who is a staff attorney with CLEAR. Outside of her work with CLEAR, Princess serves as an advocate with the Parole Preparation Project, which prepares people serving long-term indeterminate sentences behind bars for upcoming parole hearings. And prior to joining CLEAR, Princess was a legal fellow at CARE New York, where she represented Muslim identifying and other individuals experiencing a broad range of civil rights issues, including hate crimes, lack of religious accommodations, and employment discrimination. And Mudassir Topa is a 2020 Justice Catalyst Fellow with the CLEAR Project. He's a graduate of the CUNY School of Law. So I will turn it over to them. Please go ahead.
Assalamu alaikum, everyone. Thanks to AMBA for organizing this and inviting us. And thanks to the other presenters, Oliver and Syed Ali and Syed Suleiman. Yeah, actually Muhammad Ali Naqvi did part of what I was planning to cover. So in our short presentation, we're going to cover just very briefly the charges brought against Mr. Zaidi and Mr. Naqvi, the implications that the case has and that have arisen with regards to collecting and giving khums under two other statutes unrelated, separate from the sanctions, the Foreign Agent Registration Act, FARA, and 18 U.S.C. 951, legal considerations for individuals who wish to give khums, and then legal considerations for individuals or organizations who have ijaza to collect khums. So I'm going to turn it over to Mudassir.
Thank you. So we just wanted to briefly talk about the charges that were brought against Sayyid Muzammil Zaidi and Aslam Naqvi, just so that we're grounded in terms of what risks we're going to be talking about. And so this information is only based on the criminal complaint and the publicly available information. And these are all allegations at this time. But Zaidi and Naqvi were both charged with violating the IEEPA, which is basically laws related to violating U.S. sanctions, which Oliver was explaining just a second ago. Zaidi additionally was also charged with violating 18 U.S.C. 951, which is a law related to acting as an agent of a foreign government. And in this case, Zaidi was charged with acting as an agent of the government of Iran without having notified the Attorney General. And these charges, we know the criminal complaint contained a lot of sensationalized allegations, And we'll discuss later why we think some of those allegations may have been included in the criminal complaint.
Thank you for that really helpful overview, Madassa, of the case. So before we get into 18 U.S.C. 951, which again is the statute that Zaidi was charged under, we wanted to go over a related statute, which is the Foreign Agent Registration Act, or FARA, because collecting khums could implicate FARA as well. So under FARA, there's a requirement that an agent of a foreign principal register with the Department of Justice. And so that begs the question of what is an agent, right? So similar to the sanctions laws that Oliver went over, you know, the law here, FARA doesn't specify it needs to be a US citizen. It doesn't need to be someone with, you know, lawful status in the US. It says any person or entity within the US that engages in political activity or solicits, collects, disperses, or dispenses things of value for or in the interest of a foreign principal. And foreign principal under FARA is defined very broadly. So as the slide says, it can include any person outside the US or any entity organized and operating outside the US. And so practically what that means is that, you know, it doesn't need to be a member of the government. It can be a foreign person. It can be a foreign foundation, for example, and the list goes on. And so, you know, we think it's important just to pause here and just make it clear that it's not necessarily a crime in and of itself to be an agent for a foreign principal. It is, however, a crime under FARA in most instances to fail to register as an agent with the Department of Justice. And there's just a few narrow exemptions to that. And the two narrow exemptions to registration that are most relevant here are first, an exemption for religious or academic pursuits, and secondly, for solicitation or collection of funds within the US only for specific humanitarian assistance. And that's medical, that's food, that's clothing, to relieve human suffering. But it's really important to know that there are exceptions to the exemptions. And what that means is that at least for the first exemption, which is around religious or academic pursuit, that exemption requires purely religious or academic pursuit. So if a person engages, or if a person or an entity engages in political activity, for example, then the exemption would no longer apply and they would need to register as an agent under FARA. And similarly, the humanitarian assistance exemption of FARA is only applicable if the person or organization is purely engaged in the permitted forms of humanitarian assistance. So again, if they go beyond that, then they would no longer fall within that exemption. And so that is what, you know, the language of FARA says, but the fact of the matter is that we don't have a huge body of law to work with for either FARA or 18 U.S.C. 951 that Madassa is about to go over. And while we do know that historically the DOJ has treated FARA more as a matter for civil enforcement, the Department of Justice has put increased focus on FARA in the last few years and has indicated a willingness to be more aggressive recently. So that's something, again, to keep in mind as you, consider giving khums.
Thanks, Princess. So now we're going to talk about the actual statute that Zaidi was charged under. This is the agent of a foreign government. And so this is slightly different than FARA, the statute that Princess just talked about. So the major difference is that in this case, it has to be related to a foreign government and it's not blanketed towards any foreign entity or person. So it's limited to only people who are officials of a foreign government or the government itself. And in this case, agency is established if the individual agrees to operate within the United States, subject to the direction or control of that foreign government or official. And importantly, there are no exemptions here. So there is no exemption for religious purposes or humanitarian purposes. And so we realize the language of this statute is even vaguer than FARA. And based on its limited usage, most cases have involved someone who is engaged in intelligence gathering activities or espionage. but not all cases. And we know of at least one court case that rejected that theory, that said it can cover any action, including those that weren't just related to espionage or spying. And we also know that people have tried to challenge both FARA and the agent of a foreign government statute as unconstitutional. And one court has even admitted that the language is confusing, but ultimately at this point, both of those statutes are still upheld as valid today.
Thanks. So what this means for individuals who want to give khums is our general advice, which we give with respect to all charitable donations, is that the safest thing to do is to give to a registered 501c3, a charity that's registered in the United States, as long as you don't have knowledge that the funds will be used towards an illegal purpose. Giving khums directly to another individual presents a few more risks, just because you may not know where the money is going to end up. So we advise doing, just research on the purpose of where the money is going. And, even giving to a charity that's registered in a foreign country, assuming there isn't a countrywide embargo of sanctions in that on that country, but even giving to a charity registered in another country would be, we think, safer than giving directly to another individual. And like Oliver said, if somebody is speaking to you about collecting khums and is not being very specific about where they're sending it or how it's going to get there, that's probably a good sign for you, not to send it that way. So for those who have ijaza to collect khums, we wanted to talk separately about the implications under FARA, under the Foreign Agent Registration Act, and implications under the statute 18 U.S.C. 951. So as Princess mentioned, that the exemption covers purely religious activity, but it's it can be essentially determined on a case-by-case basis what that actually means, and it's up to the specific unit in the Department of Justice, the FARA unit that investigates this and enforces FARA, to make that determination. So we advise consulting with an attorney who has experience with FARA to see if your organization or you yourself as an individual would fall under one of these exemptions. We'd like to note that similar to what Oliver was talking about with OFAC in writing a request for a no-name position, the FARA unit allows individuals and organizations to request what are called advisory opinions. It's kind of like seeking a fatwa insofar as you are presenting specific facts about your situation and asking them if they think you need to register. You're also laying out maybe why you don't need to register, why the exemption applies to you. But with respect to this specifically, we believe that it's very important concerning khums that this be a coordinated effort and that it not be done kind of like willy-nilly, and that it be done carefully and strategically. And we're hoping, I believe Mohammed Ali Naqvi will talk about this later and the role that AMBA might play in seeking such an advisory opinion. The second very specific thing that we wanted to talk about with respect to having ijaza to collect is implications under 951, 18 U.S.C. 951, right? So you may have ijaza to collect khums on behalf of a marjaiya that's not a foreign government, or a member or an official or an individual who has a position in a foreign government, and that may have implications under FARA. But if you have authorization, if you have ijaza to collect on behalf of, for example, Ayatollah Khamenei, who has a governmental position, this would possibly have implications under 951. And the level of the exposure will depend on, quote unquote, the level of direction or control that you or your organization receives. And so this also is a place where we think it's very important for you as an individual or an organization to consult an attorney, even if it's, especially if you have ijaza to collect on behalf of someone who has a position in a foreign government. Again, the situation is not that it's illegal in and of itself to do it, but that you have to notify the Attorney General of your position as a foreign agent. And I would just like to emphasize something Mudassir mentioned, that there are a lot of sensational details in the charging documents. Again, these are all only allegations at this point. And going back to the point of historically, most of these cases under this statute have been brought against individuals who are engaging in espionage-like activities, but they have been brought against, there have been a few cases brought against individuals not engaging in typical espionage-like activities. And so given the government's kind of aggressive posture in this case and how they sensationalized it, we think it's better safe than sorry to, if you have ijaza, to consult an attorney who has experience with FARA, because even the government itself sometimes mixes up FARA and this statute when they're investigating things. And finally, I just wanted to echo what Muhammad Ali Naqvi said in the beginning. If you or someone you know is approached about this case, or generally maybe even about like trips to Iran or things like that, it's really important not to speak to law enforcement without a lawyer present, because you don't know what they know, and unfortunately, giving them incorrect information can possibly lead to criminal charges. So here's our contact information, and we'll also share it at the end. But if law enforcement shows up at your door, the best thing to do is not open the door, tell them your lawyer is going to call them, get a name and number, so that your lawyer, whoever you contact, can follow up with them. Thank you.
And thank you so much, Naz, Princess, and Mudassir, for that excellent presentation. Hopefully we'll get people thinking so we can answer their questions during the discussion period. I'd like to now introduce two members of AMBA. Sayyid Ali Tawfiq is the founding education chair for AMBA. Sayyid Ali is a resident of the Washington, D.C. area. After receiving his high school diploma at the age of 14, he pursued his studies in the International Hawza of Qom under Al-Mustafa International University, where he received his degree in Islamic studies and jurisprudence after 6 years of study, and returned to the US just prior to starting Kharij courses. He graduated with a Juris Doctor from the George Washington University Law School in 2019. Sayyid Suleiman Hassan is an Islamic legal scholar who was born in Medina, New York, and grew up attending religious classes at the Hawza Ilmiya Wali al-Asr in Medina. After graduating from the University of Buffalo with a degree in business administration, he proceeded to the seminary at Qom, Iran in 1997. In Qom, Sayyid Suleiman specialized in fiqh and history and returned to the US after 10 years in 2007. Since then, he has served as religious director at the Beit al-Ilm Academy and as the president of the Ahlul Bayt Islamic Seminary in Streamwood, Illinois, which aims to train Islamic scholars who are fully conversant with both traditional Islamic and modern scholarship, and who can provide effective leadership and guidance to today's Muslim communities. He also serves on the board of directors of Mufid Academic Seminary and as the religious director of the Imam Asr Islamic Seminary in Alexandria, Virginia. Sayyid Suleiman also holds a PhD in Near Eastern Studies from the University of Chicago. So I'd just like to turn it over to them. Please go ahead.
Bismillah ar-Rahman ar-Rahim. So for this portion, it's just going to be a very quick rundown or general understanding to give context to what the rulings of, not the rulings, but just the general understanding of what Khums actually is. And then also with respect to this case to some extent, or how it is applied in the States. So this is going to be a very, very quick presentation, inshallah, only like 5 to 7 minutes. So as we all know, Khums is one of the main components of just Islamic taxation generally. So we're familiar with Khums, we're familiar with Zakah, we're familiar with Sadaqah. They're all three of them are referenced in the Quran. And the particular verse that's for Khums is in front of you, وَعْلَمُوا أَنَّمَا غَنِمْتُم مِّن شَيْءٍ فَإِنَّ لِلَّهِ خُمُسَهُ. And so it's explicitly mentioned that whatever it is that you gain, a fifth of it is for the categories that are mentioned below. So what is Khums generally? Khums is 20% taxation on ghanima. The most applicable form of ghanima, there are many categories of it, is the remaining income after deducting one's annual expenses. And as was mentioned in the verse, there are 6 categories that Khums belongs to or is spent on, and they're summarized into two. The first being the category of the impoverished Muslims of Hashimi descent, and that's something we traditionally know or identify as Sayyid, but actually it's Hashimi, those that are descendants of the grandfather of the Holy Prophet. And the other half is to be spent on those activities or those institutions that are, that are coinciding with the advancement of Islam's principles. And the reason why I worded it in this way is because there's a lot of overlap or just the general understanding of how we see nonprofit organizations here in this country, and also what the purpose of Khums is, at least half of the expenditures of Khums. And so anything else with a charitable, religious, or educational purpose that has been determined by the Imam himself or representatives or, the important point to note here is that they belong to and are administered by the 12 Imams of the Ahlul Bayt. And this is just a very important concept to keep in mind when it comes to understanding permission and representation. So representation, just going to give a very brief background here. The representatives were common even during the times of the Ahlul Bayt, the Imams themselves. So especially during the 7th, 8th, and 9th Imams, which they themselves were not able to receive Khums or spend them or direct them individually or have direct supervision over it. They had appointed supervisors or those to collect, those to spend as well. So it's not a new concept. And what's important today is that the representatives or acting authorities of the Imam are the marjaiya generally. It's a general form of representation. There's no specific appointing by any of the Imams, of course, as we know since we're in the time of the occultation. And so moving on, and this becomes very important for now understanding what our responsibility is, because the way we refer to marjaiya in general, the scholars such as Ayatollah Khamenei, Sistani, Makarim Shirazi, and others, it's not just based on the rulings that or expert opinions that they have presented to us that determine our obligations, our lifestyles, both in transactional worship activities or other scope of just general Islamic rulings, but also with regards to Khums, because that money has to be transferred over, or not transferred, but there's a relationship that is built there. Now, the important thing is that when we have to refer to the concept of taqlid in general, where taqlid is referring to an expert opinion, and so logically speaking or rationally speaking, you refer to the most learned of the marjaiya. And in many cases, it's kind of unclear who the most learned is, or there's several people that fall into that first tier. And so, just as how it's perfectly permissible to refer to any of the expert opinions within that category of the most learned of marjaiya, then it is also permissible to follow that formula for Khums purposes. So you may also release the obligation of Khums upon yourself by bestowing it or transferring it to other representatives, not necessarily one specific individual. Now, I'm going to distinguish that from permission and ijaza because it's very critical for not just this case, but also for understanding how this works. There's the permission to collect, and there's the permission to spend. And it's pretty self-explanatory what that means. One who has permission to collect does not necessarily mean that they can spend it on, transfer it to the impoverished Muslims themselves directly, or even for any institution. And so one of the roles of the offices of the marjas or the marja himself is to verify and improve specific nonprofit entities or individuals that have the discretion to be able to spend it on that which advances Islamic principles, whether it be charitable, religious, educational, or anything of that sort. And this is a key thing, and that is permission or ijaza does not constitute representation or agency. And this general context or this background was just here to highlight the fact that the Khums obligation is a continuous obligation, and it does not it is not stopped based on the circumstances where it becomes more difficult to either transfer it to the authority or the representative or those who have permission to collect, but also for the expenditures themselves. And the idea that some certain individuals have been sanctioned is not a new concept. If we refer to the time of the Ahlul Bayt, we'll notice that because there was a persecution that was targeted to the Ahlul Bayt themselves or the family of the Ahlul Bayt, which did not allow for them to have any sort of direct supervision or over the Khums itself, which is why there were representatives, or just people who had permission to continue the Islamic tax system. And that is it for this portion.
Great, thank you so much. And I think we'll hear from Sayyid Salman during the next portion, which is the scenarios. What we'd like to do now is present 4 scenarios for individuals, which we think will, which may be common scenarios, hypothetical scenarios that may apply to a lot of people in our community, and have the panelists share some insight. And then 3 scenarios for organizations which may be collecting and distributing homes. So we'll start with the first one here. I'll read it out. Number 1, a community member wants to fulfill their homes obligation by making a donation to their local mosque or domestic 501c3 nonprofit organization which has permission or ijaza to collect from Ayatollah Khamenei's office. So floor is open. Please go ahead. Whoever wants to take that first.
I'll say a few words. Bismillahir Rahmanir Rahim. Assalamu alaikum to everyone. As we heard in the presentations, an abundance of caution is certainly justified when paying a khums obligation. So even if a particular transaction might be arguably legal, but if there is a potential that it might be, marked and questioned, then as a conscientious citizen and Muslim, we should exercise an abundance of caution. And one of the reasons for that is not just the potential legal consequences, but also because, as Sayyidadi mentioned, khums is primarily an obligation that we owe to the recipients and to the imam, who is the person in our theology that is authorized by God to manage those funds and make sure that the recipients receive it. And in that process, the marjaiya who gives the ijaza is simply a means and not an end to make sure that that religious obligation is conducted properly. So given that, fortunately, we have a very straightforward avenue, which is that our marajir, including Sayyid Khamenei, say that if there is another scholar of equal knowledge, then you can continue to follow whichever scholar you follow for your individual obligations, but you can give your khums on the basis of that other scholar that is, quote unquote, safer or less likely to raise any questions. And given that the vast majority of actual uses for khums are the same, they're shared across different scholars, and in some cases, an institution may be authorized by multiple scholars. That is simply a matter of your intention and the basis on which you're giving it. It doesn't actually mean that the funds are going to go to a different cause than they otherwise would. So in this case, if that organization does have the permission of an other scholar, the safest course of action is to make that intention. And if you write down who your marjaiya is, you put that other scholar and give the funds And that way you've fulfilled your religious obligation, you've exercised an abundance of caution, and the funds have gone to their intended religious or charitable use.
Thank you so much, Said Salman, for that a comprehensive analysis based on what we heard today that I think will be very useful to for the community members to hear. So thank you again to all the panelists for their presentations. So we'll go ahead and move to the scenarios. Did anybody want to jump in for this first one?
I can jump in.
Okay.
So first, let me echo and that was very well said. And I think certainly an abundance of caution is warranted. Another important point raised is even if there are arguments as to whether at the fringes of the scope of these very broad sanctions, whether they apply or not, the entire process of having to deal with the US government in an adversarial situation, have to deal with an investigation and so forth is not worth it if you can take easy steps to put yourself on more solid ground, from a legal perspective. As for the first scenario, I think we're speaking, if I understand correctly, the scenarios are more on the aspect of the individual side rather than the organization here. If you're a community member and you want to fulfill your obligation by making a donation to, a local mosque or domestic 501c3, which has permission from Khamenei's office, I think that there are certainly some risks there from a sanctions perspective. I'm not sure that the federal agencies would go after every single donor that might be involved, but if they choose to go after an organization for having some type of relationship with parties in Iran, as an individual, you may not want to be caught up in that. And if there are easy steps that you could take to avoid that type of exposure or liability, I think it would make sense to do so. At the same time, if there are organizations that may have, ijaza from, for instance, multiple sources, or, one might be in a position where it's not entire. It would come down to, maybe the receipts or the paperwork and, what intention is being shown. And so again, just be mindful as you move forward. These sanctions are extremely broad. And even as an individual, you may be in a situation where there could be an allegation that you're facilitating relationships between other parties, that are upstream.
Any other thoughts on this, Naz?
We don't have anything to add on this.
Okay. Great. I think we'll move to the second one. Second scenario is a community member wants to fulfill their Khums obligation by transferring money to a charity in Iran, which has permission, ijaza, to collect from Ayatollah Khamenei's office.
I'll go first again.
Sure.
Here, I think you have a much clearer scenario of something which falls within the scope of the ITSR and the Iran embargo, sending funds to Iran. There are general licenses for certain not-for-profit and charitable activities that organizations can act under and be authorized to engage in certain activities in Iran. Charities that are solely based in Iran, however, are unlikely to fall under those general licenses, and any transfer of funds to Iran is fraught with peril because of the practical logistics of moving money to Iran and the lack of banking connections between the United States and Iran, and the fact that US banks in a large sense act as the gatekeepers for sanctions issues, and they're the ones who are primarily reporting to OFAC so that OFAC can enforce the sanctions. OFAC is a very small office and they're getting their information from the banks. So anytime you're engaging in transfers which may involve Iran, it's always important to make sure that you can clearly justify what exemption or general license your transaction is moving under. If not, a specific license would be the appropriate way to do it.
Clear or say?
Nothing else to add on that. Thank you.
There were a few follow-up questions to the previous scenario. Should we wait until the end of the scenarios to address those, or what's the best way to?
I think we can address them if you see something in the question and answer that you think applies. Sure.
Sure. So just going back to the previous one, I think there was one question that changing taqlid is not a solution. Well, this is true, and hopefully, gradually there will be greater clarity about what is going to be red flagged, what will not be red flagged legally. But remember that Islam and Islamic law has a built-in flexibility for different circumstances. And this is not the first time that a government looks with suspicion, maybe excessive suspicion, towards normal religious practices of Shia Muslims. This has kind of been our history. So that built-in flexibility is meant to allow us to fulfill our religious obligations, live a moral and upright life, and make sure that our property, our livelihood, our dignity is preserved. So if, without bending any of the laws of Islam, you're able to do that and avoid even raising suspicion, then not only do we have no obligation as Muslims to be that one case that's going to, test the law, but we might actually have an obligation, because if that risks Khums funds, and remember, Khums funds need to be given to the recipient. These are for worthy causes. It's like a debt that I have to pay. So I, as a believer, don't have the right to prove a point because I want to officially give it in the name of a particular marja or scholar. To give that khums, maybe tie up those funds or cause legal jeopardy to an organization or myself, even if I believe that I'm in the right and I will eventually be acquitted, and in the clear. So I hope that clarifies it. We're not speaking about bending Islamic law in any way, but within the built-in flexibility of Islamic law to exercise our religious obligations that allow the Khums funds to reach the charitable cause, help the community, help a needy person, help a religious institution with the least possible delay or risk. I hope that that's clear. It's not at all about changing taqlid in order to try to avoid a stand for principle. This is our principle, to use the flexibility of Sharia.
Thank you.
There's a bunch of other questions. I'll try to answer some of them on the chat window, and then we'll see if we need to do it orally.
Sure. And we can take them at the end of the individual scenarios as well, a few more.
Yeah, I think some of them might be answered as well as we go through the scenarios.
Okay. The third individual scenario is a community member wants to fulfill their khums obligation by taking cash to donate while going on ziyarah, the religious pilgrimage to Iran.
I'll go ahead and go first on this one. I think certainly, assuming the community member is a U.S. Citizen or permanent resident, there are certain general licenses which allow for taking cash while traveling to Iran to provide as a personal, non-commercial gift to someone who is ordinarily resident in Iran. That general license specifically excludes charitable donations. They do not fall under the personal non-commercial remittance general license. Typically, specific licenses are required for that. When you travel to Iran, you are there is that exemption for travel to Iran. So all transactions you engage in that are ordinarily incident to traveling somewhere and paying for general living expenses, there are some exemptions and general licenses for those types of activities, but charitable donations, as far as I'm aware, there's no general license for that. So this would appear to be, you know, risky activity that I would not recommend.
So just
Sure.
clarify that. I'm sorry, just to clarify that before you go, Naz, that you are allowed to take cash when you go to Iran, right? I mean, but it's meant to be only, is it like less than $10,000 per person, but is it only supposed to be for personal expenses? Like you cannot take any cash to get, like even to say, give to poor people or, you know, help, you know, just to give a donation to somebody, like you're actually not supposed to donate to anyone while you're there. Is that the law?
Yeah, so there are, again, there's some general licenses that allow certain not-for-profit activities. If you can find that what you're doing falls under that in some way, that may be okay, but those general licenses typically apply to organizations, not to individuals. As an individual traveling to Iran, technically you're not allowed to engage in really any activity that's either not related to your travel and basic living expenses or falling under another general license. And while there is an exemption for the donations of humanitarian goods, for instance, that has to do with sending goods to Iran. Rather than you know, cash or funds. So that is as far as I'm aware, you know, there's no authorization for that without getting a specific license. There may be some arguments on the outside, so it's a bit of an open issue. But you know, there's no clear authorization for, you know, taking money over there and donating it. As far as the limits go, there is a reporting requirement when you travel and you move more than $10,000. That's not a restriction, as far as I'm aware. That's just a reporting requirement.
Oh, I see. Okay. Sorry, go ahead, Naz.
I was just going to say that I don't have anything to add.
Okay. Sayed Salman or Sayed Ali? We can move on to the next one.
I think so.
Okay. And the last scenario for individuals, a community member wants to fulfill their Khums obligation by making a donation to an individual or organization in Iraq that will take the money to Iran on the individual's behalf.
So I'll go first on this one. Again, the way the U.S. sanctions work, you know, OFAC really cuts to the heart of the issue. They, you know, working with intermediaries, for instance, never resolves any type of sanctions issue. OFAC will pierce through that in their analysis and application of the regulations. So here, working through an intermediary based in Iraq would not help if the way you're donating the money in the first place is not appropriate. With that said, for instance, if in a slightly different scenario, if you were, for instance, sending funds to family back home, and you were doing that through an intermediary in a third country, that would be the typical way of doing it. There's no direct banking relationship between Iran and the United States, so all movement of funds to and from, you know, the United States and Iran needs to go through a third country, and a number of folks use, you know, intermediaries that are based in these third countries. What matters is how you're donating that money, whether you have a general license that supports what you're doing and authorizes it. And, you know, if not, whether you have a specific license, perhaps. You know, some organizations may have a specific license that authorizes certain activity.
Great, thank you. Are there questions? Naz, did you have anything on that? Or?
No.
Okay. Or Sayed Salman or Sayed Ali on that?
No, I think that's more of a legal issue than a religious issue, unless there are any religious aspects of it, which maybe somebody can put in the chat if they do have.
Yeah, I'm just looking through the chat to see if there's anything that's related to what we just went over. there was one person who said that the government's also calling Ayatollah Sistani an agent of Iran. So we're going to get into that in the organizational part of the scenarios. That's correct. In the complaint, it does say that Ayatollah Sistani is a surrogate, an Iranian surrogate in Iraq, which I think to most of us who know about how the marjaiya works and the politics works, it's a laughable connection, but nonetheless, that's what the government has said. So we're going to get into that and see how it may affect Khums giving to those who have ijaza from Ayatollah Sistani, the organizations that have ijaza from Ayatollah Sistani as well. And
I think a couple questions on this general aspect. So let me just clarify that from a religious perspective, your job is to make sure that you are giving your khums according to what God has commanded. And the role of your marjaiya taqlid, whether it be Sayyid Sistani, Sayyid Khamenei, somebody else, is to tell you what the conditions are to fulfill that divine command. Just like, if I want to pray, I refer to their rulings to make sure that I'm doing it correctly. So if they have given authorization to a particular cause or a particular organization or whatever the case might be, just like with your prayer, your intention does not need to say that I am praying according to the judicial ruling of scholar X. You're praying to fulfill your command, and express your gratitude to God. You're making it conform to the ruling of an expert in the field. So as long as you're fulfilling your khums obligation, you don't need to specify the name of your marja. We do that for accounting reasons, and also because in many cases, organizations that handle funds from different scholars, they might have a different percentage that they can use for one purpose versus another purpose, and so there might be other logistical reasons, but it's not religiously required for you to make that specification. What's religiously required is for you to make sure that your giving corresponds to the ruling of whichever legal authority, shari, religious legal authority you follow. So that might help a little bit. And then if there is an organization that is authorized by several scholars, then you just need to make your action conform with your religious obligation, and that suffices.
Okay, I'd like to move on to the organizations. So these three scenarios have an A and a B. You can see the only differences between the marja who's mentioned. So a local mosque with ijaza from Ayatollah Khamenei wants to receive khums from community members. Same scenario for Ayatollah Sistani.
Oliver, why don't you go first?
Okay. I think the local mosque in 1A is certainly in a tough situation, given the recent case, but also given perhaps some of the differences in the U.S. government's position on what an ijaza is, versus perhaps some other interpretations of what that might be and what exactly is the relationship there. Nonetheless, given how broad the sanctions are and the fact that Khamenei is on the SDN list, that seems to me a very risky proposition. I think OFAC certainly has room to rule that it is engaging in the activity in 1A would be in violation of some of the sanctions regulations, either the Iran country-wide embargo, the SDN list restrictions, or both.
I'll just add on this that in addition to the sanctions-related concerns that this raises implications under FARA and the statute that Mr. Zaidi was charged under. And again, just to be very clear, it's not obvious to us on the facts, even as publicly alleged by the government, that simply having ijaza to collect khums would be enough to be considered to be in violation of the statute, but it's important for us to be cautious given the government's aggressive stance in the case. And in terms of having ijaza from Ayatollah Sistani, I think this kind of goes to something we were talking about earlier. It's not, as of right now, my understanding, Oliver, correct me if I'm wrong, he's not on the SDN list. He's not a blocked person.
Ooh, I do not know off the top of my head. I do not think so.
Yeah, I think we tried to check this last week. At the very least, I don't believe he's on the SDN list. So it wouldn't raise implications with regards to sanctions right now at this moment. Obviously, if sanctions were put in place against him, if he were added to the SDN list, then any transactions going forward might raise sanctions issues, as Oliver can speak to. But my understanding, Oliver, correct me if I'm wrong, is that they wouldn't be backward looking, like it wouldn't apply to anything that happened before he was added.
So if someone's added to the sanctions list tomorrow, would my activity today be in violation? Not for the reasons that that person's on the sanctions list. You know, they oftentimes people are put on the sanctions list for being involved in certain types of activity that are tied to embargo territories or SDN organizations. And if you were involved in that activity, there might be something in the pipeline for you. But here, but in a case like this, you know, I don't know that that would necessarily apply.
Right.
Yeah.
Thanks. And then just finally going back to the point we talked about earlier, which is that we're hoping AMBA can play a coordination role, specifically with regards to possibly seeking an advisory opinion about whether someone who has ijaza or an organization that has ijaza to collect on behalf of Ayatollah Sistani needs to register under FARA, and whether that there are implications under FARA. So as of right now, it's not quite clear to us. Unfortunately, I'm going to have to give the bad lawyer answer of it depends, and we're hoping that we'll be able to find out.
Yep, and AMBA will be in discussions at our next board meeting this next month to discuss the possibility of really, instead of individual organizations requesting an advisory opinion, AMBA doing it on almost on behalf of the community, so we can get an answer or advice on how to proceed on that, because we don't want to put, with this administration especially, put any organization in harm's way. I don't know if you want to mention that, Oliver. We had discussed that previously, right? Yeah,
we did. I think you covered it. Something just occurred to me actually for 1A and 1B, or something I forgot to mention earlier is, if you're in the position of an organization where you have an ijaza from a Kavani's office, that also puts you in a situation where, if funds are coming in and there's possibly an SDN interest involved, do you have a responsibility to block? Do other people have a responsibility to block those funds for having an SDN interest? And what type of reporting is involved? It goes beyond, there's layers to the sanctions issues there that pose, dangers for organizations.
Great, yeah, and we, if and when AMBA does decide to do this, we look forward to working with you guys on how to formulate that. Hopefully, so can move on to the next scenario here. 2A, a local mosque with ijaza from Ayatollah Khamenei wants to distribute the collected Khums funds to other registered domestic charities or directly to the individuals in need in the US. Same question, same scenario with Ayatollah Sistani in 2B.
Yeah, I think that the answer here is, while the perceived egregiousness of the activity in the eye of the US government may change if the money's moving overseas or staying domestically, the sanctions issues are not really changing related to, a relationship with Khamenei's office, and particularly what that might entail. Does that mean that your organization has been reaching out to that office, requesting certain services from them and certain paperwork? And so simply limiting your activity to domestic activities in the United States is not sufficient to insulate from the broader sanctions issues there.
And I'll just add that that the activities in the United States raise both concerns under FARA and 18 U.S.C. 951 if you're collecting on behalf of somebody who is an agent of a foreign government or an official in a foreign government. In fact, like those statutes are specifically targeted at activity in the United States. So even if the money is only being spent in the United States, only being collected and spent in the United States, even if it's being done with a certain level of coordination with either of those parties, it raises concerns under FARA and 18 U.S.C. 1951. And so again, it's just to go back to like what we said before about consulting an attorney, and hopefully AMBA will be able to look into this.
Yes. Great. And the last scenario before we get to questions, a local mosque wants to advertise that they have ijaza from the office of Ayatollah Khamenei. Same scenario for Ayatollah Sistani.
In a way, I think that this hypothetical cuts to the heart of a lot of the issue, which is how this information is being conveyed and advertised and described on paperwork or on receipts and so on, will have a lot to do with how the sanctions laws may apply. I think it's already a fairly formalistic kind of relationship and kind of a system, which makes it easier to apply some of these contractual commercial sanctions restrictions to it. But to the extent that there is active advertising as to that relationship, I think that certainly would be seen as a red flag by folks in the U.S. government, and could just heighten the risks of some type of enforcement action.
Yeah, and I would say with respect to Ayatollah Sistani that it would similarly possibly could raise prospects of enforcement, civil enforcement under FARA, to the extent of, possibly them just, demanding that the organization or the mosque register under FARA. But again, that will depend on what are the activities of the mosque and things like that.
Yeah, and Naz, I would also like to reiterate again what you said before. My comments have really been focusing on the A section of these hypotheticals with Khamenei's office and that relationship. As far as Sistani goes, as far as I'm aware, he's not on the sanctions list. While there may have been a line, about him in, either the affidavit or the complaint that was filed. What I've been told, and maybe someone else can chime in, my understanding is, that's not the way that the system works, and that they are independent with respect to the role that they would be filling here. So my comments about all the sanctions risks were focused on, 3A, 2A, 1A related to Khamenei's office.
Okay, yeah, just playing on that. Looks like the number one question in the Q&A, looks like 6 people have upvoted it, is, so if a U.S. nonprofit organization has authorization from Sayyid Sistani's office to collect khums for use in the U.S. for the expenses of the U.S.-based Islamic Center, is it necessary to register as an agent of the foreign entity, in this case Sayyid Sistani in Iraq?
Yeah, I have to give the disappointing lawyerly answer of it depends. And this is where we're hoping AMBA can play a role, particularly with respect to anyone or any organizations that have ijaza from Ayatollah Sistani to collect, and whether the facts surrounding the level of coordination and or the activities of the organization, for example, whether they qualify for an exemption, the religious exemption, would mean that they don't have to register under FARA. So this is something where we're hoping that AMBA can help play a role in pushing that forward. And I'll just, I think follow-up question to that is, I think we answered it, but just basically like it's not backwards looking. I think these things like it's not that, oh, you did it now, so if the sanctions get imposed a week later, that transaction is going to bring you problems. I'll just like give you an example. Last year, we were contacted by a few people who had been approached by the FBI because they had attended a conference or conferences organized by the New Horizon organization in Iran that had been added to the sanctions list at the same time that the Revolutionary Guards had been added. And the clear message from the FBI was that like, well, no, your attendance at that conference before the sanctions were in place wasn't a problem, but obviously if you went now, it would be. So.
Great. Yeah, thank you for reiterating that. And again, AMBA is looking into playing that role, inshallah, for on behalf of the community. So some of these questions I think maybe just have been covered in some of our conversation, but I think it's okay to repeat just to clarify and reiterate. The next question, can organizations that collect khums on behalf of sanctioned person keep and spend funds in the US without violating the law? Again, it sounds like there's a lot of ifs. And
yeah, I think that the general answer would be no, not unless there's some exemption or license which applies.
Okay. Oliver, you saw this question under the ITSR, any donation amount?
Yeah, I did. So I believe that the ITSR does not have any kind of monetary amount as to the activity it's involved in. I've worked on cases where there have been gifts in the millions of dollars with value, and they move forward under general licenses which were available. So I don't believe there is a cap on the amount. There is a general license that has to do with gifts that you are sending. Like if you were to, purchase something as a gift for family and send it to them, and there is a cap. I believe it's $100, but you may have to look it up, or maybe we can follow up later with that exact amount. But that's for gifts, not for donations. And generally speaking, the Iran sanctions apply even if it's free services that you're providing. In some cases, if you're providing services for someone and not charging them, that would not, for instance, absolve you of issues under the Iran sanctions. So I don't believe there's any, specific figure 100, 200, 500 that provides some protection there.
Okay, so two questions I'll put together because they're related to Yemen. If a 501c3 organization is collecting khums or donations for humanitarian aid to Yemen, can an individual contribute to that organization? And I'll kind of add a little bit to that, like without knowing or understanding the route of distribution. And then it talks about, actually, let's take that question first. The second one may have some religious dimensions in it. So.
Okay, from an OFAC perspective, on the Khums side, it's going to depend again on whether it's related to Khamenei's office or not. Generally speaking, Yemen, while there is a Yemen sanctions program that OFAC maintains, it is not a countrywide embargo. And so what's going to matter here is that the activities involved wouldn't be involved with anything that would violate sanctions, not involve any SDNs, for instance, not involve Iran in any type of way, but simply donating to someone who might be working with projects in Yemen by itself would not be enough to make something unlawful.
Okay, great. So this one is an interesting question. and I would expand this to, does Islamic Relief have specific permission for humanitarian aid to Yemen? Again, I don't think anybody can answer that here unless you know from personal experience. But actually, I would add to this, there's organizations that are not, I guess, for example, Shia run, like Islamic Relief. Do any of you know whether it's possible for them to have permission to collect khums because they're a Muslim organization, or does it have to be specifically like, you know, under the guidance of a marjaiya, representative of a marjaiya?
It depends. So sometimes, you know, when there is, so the primary purpose of khums is not just for the poor or poverty reduction. It's also to preserve the spiritual and religious and intellectual continuity of the Shia Muslim community. But for many recent cases where there have been natural disasters or extreme need due to floods, due to earthquakes, almost all of the marajia have said that people can give, you know, a set portion or whatever of their khums to address that immediate humanitarian crisis. And if that's the case, then it just needs to get to the recipients that are specified. You know, hypothetically, a marjaiya might say that this needs to go only to people who have lost their homes, for example, or have been, you know, whose houses were destroyed in the flood. And then it can't just go generally, say, to building a well or a school in that village. It has to go to that purpose. So in some cases, there are those allowances for a humanitarian crisis, and if that exists for Yemen, then it can be channeled through any means, as long as the recipient fulfills the requirements specified. That's again a general answer. It's not a specific answer because I don't know, you know, how Islamic Relief directs their funds, and which marajia may have given a partial or complete permission to send funds to Yemen or for specific reasons. But I do know there are organizations that are able to channel charitable funds to Yemen.
But it would be, they wouldn't give permission to give it to any specific organization. They would say as long as it is for this purpose, based on your niyyah.
It could go both ways. So when it comes to natural disasters, in the recent past, we've seen several examples where it hasn't been an organization. It's been, you know, X number of people, thousands of people have been affected by this natural disaster. Go ahead. If you know somebody, give it directly. And perhaps, you know, the logic in the scholars' ruling is partially to allow for that direct connection, minimize red tape, and, you know, administrative expenses and so on. In some cases, there are organizations that are authorized. So there, you know, in Iraq, for example, there's, you know, charitable organizations, orphanages that are specifically authorized. So it can go both ways.
Okay, great. We are just at 10 o'clock, which I think is essentially where we wanted to hit. But we have still 82 participants, and people are engaged, and we still have a few questions. Would the panelists mind staying another 5-10 minutes to get through some more of these questions?
Sure.
Yeah.
Thank you so much. Are there any other marajaiya who are on the SDN list, as far as you all know?
Not as far as I know, but you know, that is an interesting question. We can look in, you know, I can run the searches after the presentation.
Yeah, that would be great. And in terms of names, maybe Sayyid Ali, Tawfiq, we can possibly, you know, send over some names for search. That
Absolutely, inshallah.
Okay, great. So, okay, this is a question about the case. Maybe Naz, if you want to take this. Looking into international and national changing political dynamics, what if the sanctions are lifted or Sayyid Khamenei is removed from the list? What effect could this have on the case?
Oliver, correct me if I'm wrong, but as long they can still charge them for violating the sanctions that were in place at the time that those alleged violations of the sanctions took place. So it wouldn't necessarily matter that, like, let's say a week from today, the sanctions against Ayatollah Khamenei are reversed, but they were in place at the time the alleged violations occurred, and that's really all that matters, unfortunately.
Yeah, and it's not at all unusual to see OFAC or the Department of Justice charging people under sanctions programs that have been revoked. You know, at the time that the matters are decided. For instance, you can see Burma-related or Sudan-related sanctions cases still show up in OFAC civil enforcement notices, even though it's been, you know, 4 or 5 years since those programs were removed.
Okay, great. Thank you. Yeah. Yeah, this is a little bit corollary. So ijaza not meaning agency. From a religious perspective, it was mentioned that ijaza does not mean agency, or actually no fiduciary duty is, you know, present. But is that the U.S. government's position? And I'm guessing that that's in flux.
Yeah, that's essentially kind of the question that this case presents. Again, we'd like to point out, as we discussed before, that historically most of the cases involved espionage-like activities, and that's why we saw some of that inflammatory language in the charging documents relating to alleged connections Mr. Zaidi had with the Quds Force and his use of encrypted messaging applications. That is in line with other charges brought under this statute. They have to allege direct connection between the individual charged and the government. It's not clear, because so few cases have actually been brought under this statute, and because it's so broad, whether simply having ijaza in and of itself could be considered to, and not informing the Attorney General that you have that you're acting in this way, particularly on behalf of somebody in Ayatollah Khamenei's position, would be considered a violation of the law.
Okay, this question is for Sayed Suleiman. You said it's important for us to make sure the Khums is delivered without issue to the people who it is due to. Would it be possible for the ulama to address this in a general ruling or message to the Shia community in the US, perhaps something our religious orgs can post on their websites or announce at their centers?
Yeah, that's a good idea. It's important to remember that historically Khums has been a very intimate and a very personal act, because it's Islamically not considered a tax. It's considered to be an act of worship. And so it's just like prayer, it's just like fasting. It's a form of gratitude to God and obedience to God. And so like any other act of worship, it's an intimate act, and you give it to an organization under the guidance of your marja because you have trust in that individual. And that lack of institutionalization is one way that, in the face of persecution, in the face of so many, you know, historical and current challenges that the Shia Muslim community has faced, the institution has preserved its answerability to you as the individual, you know, and preventing institutional corruption, because at any moment, you as the person who has that Khums obligation make a moral choice that I'm giving it to this organization, to this individual under the guidance of this person. So it's an act of trust at every instant. So because of that intimacy and that historical practice and that historical logic of Khums, it's a little bit difficult to give generic information and say, you know, you can give it to any organization that's serving the cause in this way. But with that caveat, there certainly are certain general guidances that I think, guidelines that I think organizations can look into giving. And hopefully that can provide some guidance, even though there is a little bit of ambiguity, I think, from what we're hearing from the experts and how the government might apply certain guidelines. So given that ambiguity, it's not always easy for a religious organization to say that, this is the way to fulfill your religious obligation. But I think AMBA will be looking into that, and we can also look with other national religious organizations to try to get some guidance.
Great. Thank you. Just it looks like a more general question here. Are there any efforts by CLEAR or OFAC lawyers to challenge these wildly broad sanctions? While I understand we have to figure out how to meet our obligation within this context, curious about whether any effort is happening to challenge these regulations, and what's the process for that? Naz, is there?
Actually, maybe Oliver can speak to this better. I don't have much experience challenging sanctions, but maybe he can talk about how difficult it's been.
I mean, so there would be room to, for instance, seek interpretive guidance from OFAC and kind of try to make the case why this should not fall under the prohibitions, or if it does, why there should be a general license to authorize some of this activity, or why OFAC should issue an FAQ or some other type of guidance clarifying what their position is with respect to this. That would of course raise the issue, with the Office of Chief Counsel at OFAC for them to review. Sometimes organizations may not want to seek interpretive guidance if they don't want a firm position one way or another. The rules seem a little ambiguous to them. But it's certainly an approach we can take, would be to file and seek interpretive guidance on some of these issues. The problem is, for instance, if OFAC provides an unfavorable response, or challenging it in the court, for instance, may be difficult because courts offer a lot of deference to OFAC. OFAC is at the intersection of administrative law, foreign policy, and national security. And in each of those separately, courts defer greatly to executive agencies on interpreting their own rules. Since OFAC is at the nexus of those three, they've been given extreme deference on some of these interpretations. But given perhaps how big of an issue this may be for the community, I think there is an argument that it may make sense to seek some type of interpretive guidance and at least get something clear from OFAC one way or the other.
Great. Okay, since we're nearing the end, I just want to pose two more questions. The first one I'll combining two questions actually about other countries, not the ones we mentioned. How unambiguous are the laws regarding sending or donating funds charity, either to marajahs or charity organizations sanctioned, endorsed by marajahs, to charitable organizations on the ground in Beirut, southern Lebanon, also sending money internationally to a non-sanctioned country like Pakistan? Are there any risks to sending money to individuals who are not on the SDN list?
There are always some risks when it comes to sanctions because it is a strict liability regime, and depending on who is involved on the other side and who they may be associated with, who might control the organization, for instance, there are always some risks. But I think that when it comes down to it, the right steps would be to do your due diligence, find out who it is you're contributing to. You can search them against the sanctions list, which is publicly available on OFAC's website. You can take a look at the organization as well and screen it. And depending on the territories, so for instance, Beirut in southern Lebanon, there are some Lebanon-related sanctions, but that's also not a countrywide embargo. That's just a list of people under the Lebanon sanctions. And so if you do your checks against the list, you can, by doing that due diligence, put yourself in a position to satisfy yourself that there's no one inappropriate involved. And at that point, you have some confidence to engage in the activity. in a way that doesn't violate US law. Unfortunately, it's hard to always be 100% confident and correct, particularly in this area of sanctions, because a lot of these cases involve, for instance, people lying about who they really are or where the money's really going. And because it's a strict liability regime, you can be on the hook even if you weren't aware of what was going on. But that's just the way that the sanctions regimes work.
Yeah, and I believe that's written into Patriot Act 2 as well, correct? That if you financially transfer funds and it ends up in the wrong hands, you can be liable even if you didn't know, right, who it was going to, from what I understand.
Yeah, I've not dealt with the Patriot Act on that, but I do certainly know under sanctions that's the way that it works, and I think there's a large overlap there. But yeah, it's a risky world in terms of sanctions.
Definitely. Last question, I think, is, did it disappear? It was basically someone saying the bottom line is what questions can we ask organizations before we donate to them to keep ourselves sort of secure and safe?
I welcome the rest of the panelists to join me on this, because I'm not sure I'm going to cover everything here. But I think some important questions to ask is first, when donating the funds, keep in mind that donations related to Khamenei's office in Iran are going to raise sanctions issues on their own. If you believe that there might be some connection there, you can ask the organization what general licenses or exemptions it believes allows it to proceed in that respect. Beyond just that, it's always important to ask, where is this money going to go? How are you going to move it there? And do you do any due diligence on the projects you're involved in? And what is that due diligence? Those are all those helpful first questions that will give you an idea of how seriously the organization takes its due diligence and compliance efforts, and give you a little bit of confidence and a little bit of information to kind of do some of your own research there and see if you're comfortable.
Yeah, I agree with what Oliver said in terms of doing that research to make sure that that there are not issues with respect to where the money is going and how it's getting there.
Great. Thank you so much to the entire panel for all the work that you all did over the last few weeks to put this together. Hopefully the community benefited from this. We have a short poll for people who are remaining. If you could just let us know how we did. And while the audience members are doing that, if I could ask either Sayyid Ali or Sayyid Sulaiman, if you could just lead us in a short dua before we end, inshallah.
Sayyid Ali, would you like to go ahead?
No, please go ahead.
So I'll begin in Arabic. Bismillah ar-Rahman ar-Rahim. Subhana man la ya'tadi ala ahli mamlakatih. Subhana man la ya'khudhu ahla al-ardi bi-alwan al-'adab. Subhana ar-Rahuf ar-Rahim. اللهم اجعل لنا في قلوبنا نورا وبصرا وفهما وعلما إنك على كل شيء قدير. We pray to God that in a world that is filled with so much injustice and so much evil, that He allow us to be agents of conciliation, of peace, to live upright lives, and to work towards making the world a place that is filled with mercy, that is filled with justice, and that is filled with grace. Ameen.
Ameen. Allahumma salli ala Muhammadin wa ali Muhammad. Thank you so much. Thank you again to the panelists, and I will just leave the thank you screen up. Our panelists are more than happy to take questions afterwards. If we apologize if we didn't get to your question, but please feel free to contact Amba, CUNY Clear, as well as Oliver, who've all graciously volunteered their time afterwards to answer your questions by email. And everybody have a good night, good evening. Take care now.
Good evening, everyone.
Assalamu alaikum.